welcome back to PSLabor Talk. This week we're sitting down with Cliff Hammond, our friend from Nemeth Burwell, who's been on the show a number of times before. How are you today, Cliff?
Doing great. Thanks for having me.
And over the phone, we're here with John Raudabaugh, former presidential appointee to the National Labor Relations Board and a Reed Larson Professor of Law at Ave Maria College in Florida. How are you today, John?
Good, thank you.
Oh, great. So today, gentlemen, we're going to be covering the National Labor Relations Board, the future of the board, some of the things that have been happening, especially over the last year, in fact, especially since last January. Now, Cliff and John especially here are experts on the NLRB, so we're very excited to have them on. John, the first question I have, I'm going to direct it right at you. It seems to confuse a lot of people. Is the NLRB really dead in the water? What's happening with the board right now?
Well, having served as a board member, I don't want to give too much of an insider's view. It'll put people to sleep. But what we have is, as most people are aware of at the moment, we have 3 people occupying 3 positions out of what could be a total of 5 under the statute to hear and resolve cases involving our National Labor Relations Act. Of the 3, the Supreme Court 2 years ago in New Process Steel held that you have to have a minimum of 3 people serving, or what they decide is void. So there's 3. But of the 3, 2 were recess appointed along with several others who are no longer there at the moment. They were recess appointed on I believe January 4, 2012, by President Obama at a time when Congress was in recess, and it is argued that what the president did was unconstitutional according to the interpretation of the Constitution and somewhat almost a 200-year history of various decisions and attorney general opinions. And of course that's being litigated, and it was challenged in this Noel Canning case where the D.C. Court of Appeals, in a case that involved an unfair labor practice challenge to an employer out in the state of Washington, and the issue was raised, well, the decision of the board is invalid because a majority of the panel that decided the case were invalidly put in power by the president. And the D.C. Court of Appeals agreed and held 2 major points. One is that any recess that is going to be filled, any recess appointment, the recess itself, when the term ended by the outgoing individual, it had to occur during a recess between sessions of Congress, or an intersession recess, and the recess itself has to take place during that same intersession recess. Well, the arguments on the other side are very out front, and they say that, well, that would almost strip the president of any power to keep positions filled in government, and the fact that it would have to be a recess occurring during an intercession recess of Congress limits it even further to where it would be impossible to keep the government functioning. And at this time, there are more than 33 cases in different appellate courts around the country, according to the acting Attorney General at the board. But now, to your pointed question is, what's going on? Well, there's no question that we've had extreme decisions by the Clinton board, followed by the Bush board, then followed by the Obama board, pushing the pendulum back and forth and back and forth. And we've seen it right up to the present day. Now, whether this continues, the president has renominated all 3 people on the board, the president has renominated 2 of the 3 people, the 2 recess appointees, Ms. Block and Mr. Griffin, and the chairman's term ends by statute on August 27th of this year. So with all of that approaching, the inside the Beltway read is that all three of these individuals may become a little more cautious in what they do between now and August, so that it doesn't further screw up their chances of getting reconfirmed or confirmed by the U.S. Senate. Now, given that two of the three were viewed as illegal recess appointees, I question whether the Senate will have a majority to reconfirm two people that served improperly now by an action by the president. But once they came into office and the D.C. Circuit issued an opinion, they blew it off and continued to issue decisions. Now, as we speak, as of yesterday, there have been a total of 801 unpublished decisions with arguably unlawful recess appointees, 624 published decisions for a total of 1,425 decisions during the Obama administration, where participants in the case were arguably unlawful recess appointees. So it's a potential huge mess, not unlike what we went through in the New Process Steel case, where the board had gone down to 2 members, and the Supreme Court essentially had them readdress and reconsider every one of the decisions when they got back up to a 3-member board. So it appears that right now things may slow down. On the other hand, never rule out the NLRB and the interests of both labor and management. The statute still is in existence. There's been efforts to change the statute over the last 30 years that have never been successful. There are currently several bills in the House and Senate to amend the statute, but query whether they'll go anywhere. And we understand that the AFL-CIO is even considering a redraft on their Employee Free Choice Act that went nowhere. And on the other side, we have the Employee Rights Act that was introduced by Senator Hatch. So it may appear a little neutered at the moment, but it will come back.
Hey, John, this is Rick. Based on what you were just saying, how realistic do you feel it is that, because the Obama administration is appealing this decision, and how realistic do you think that it is that they're going to negate every decision made by this and we'll call it illegal board or the board that was appointed illegally or without justification? That you said they have probably close to probably over 1,000 decisions. And this being, especially Washington right now, being the politics that are involved and both sides digging their heels into the sand. How realistic do you think that it is that they're actually going to overrule all of the decisions by this board?
Well, that's a question for the Supreme Court, if and when it gets there. And I'm sure it will end up in the Supreme Court's docket. But how that turns out, I realize that the facts are that things have changed over time. This issue has never been presented before. But at the same time, the D.C. Court of Appeals decision in Noel Canning is a very well-reasoned opinion. I can't predict how it might turn out. It may be that that the court will uphold Noel Canning, and all of the decisions will have to be revisited. But keep in mind, this issue affects all government agencies.
Right, yeah.
Again, whether the Supreme Court takes a perspective of dealing dealing with it in the context that the recess appointment could open at any time, but recesses can only be filled during an intersession recess, and play one of those issues off of the other. I have no prediction as to how it may turn out.
Well, yeah, because they're talking about all recess appointments, not just with the labor board, but in other departments also, which the politicians have to look and the Republicans have to look. Well, what happens if they're in the White House, the next election, and how is that going to affect their future administrations also? So everything's up in the air right now. Yeah, it's really confusing for a lot of people who are listening to this program.
One of the interesting things that you see is that this isn't a new issue. This is more of a fundamental issue that's been going on for several years now. And John, you referred to the new process steel. One of the problems is that Congress has been unable, and I say Congress, I mean the Senate, has been unable to get confirmations in a timely manner. And it's resulted in these structural problems at the NLRB. And whether or not this case stands or doesn't stand, ultimately timely appointments have been a problem, whether it be for ideological reasons, political reasons, whatever. And there needs to be a resolution for, I think, both sides to be able to move forward if the NLRB or other agencies are going to function appropriately. And I think that that's something that is being lost in a discussion, is that there have been pendulum shifts for years. And in addition to that, when parties don't believe they can actually address the situation through the board on a legal argument stake, they're going to other avenues. And one of the avenues that are being taken right now is through the political process. And so
I think that's right. I think also that, quite frankly, many of my friends and colleagues agree with me that it may be a good thing if we could amend the statute to have cases go to a federal district court rather than to an NLRB. In other words, once an administrative law judge at the NLRB decides a case, then it would be appealed to a federal district court, and you would get an Article III judge to decide it, and you could get away from this extreme political situation at the board where many academic studies have looked at it and found that so many of the people who've served have, if they came from representing employers, they would vote in favor of employers 85% or more of the time. If they came from representing unions, they'd vote in favor of unions 85% or more of the time. And that doesn't give anyone respect for the rule of law and neutrality and fairness. So it is a big issue. When Congress comes around to focusing on it is anyone's guess, given what's on their plate at the moment.
Well, I think that's a good point that's been bandied around, because let's just say this decision had not occurred. You would be looking right now at 3 members at the NLRB, all of which were Democratic appointees. Ostensibly, there's no minority, no dissent. So if you've got a politically charged system where most people believe it is politically charged, and you don't even have a dissent on the board, it even invalidates the possibility that an outsider looking in thinks they're going to get a fair shake. And I think that what you just talked about, John, is an alternative that people are looking at to get more of a judicial aspect to this body as opposed to a political aspect.
And Cliff, you're absolutely right about that leaning. It seems to me that labor is absolutely pro-NLRB right now, and definitely under the Obama administration. In fact, the AFL-CIO recently issued a statement urging the Obama administration, and I quote, to continue to speak out on the importance of collective bargaining rights, defend the NLRB against congressional attacks, and to work to win Senate confirmation of the president's nominees. So labor is obviously keen to have these individuals nominated, and I'm wondering, is it more of their specific political affiliations and the way that they voted on the board? Is that the reason why labor is behind these specific nominees, or is it more of a broad issue? Labor is really supporting Obama's, the president indeed at all, the ability to make those recess appointments, and they're trying to stop any sort of overhaul of the NLRB system because, the sequester's on the line. We're talking about major cuts to government. The NLRB might be in the sights, especially with all this this turbulence lately. So wondering, how do you think labor, what do you think their line of sight is on this whole issue?
I think there's probably a little bit of all of the above. Unfortunately, I don't think getting off into the sequester problem and the budget. I think they're looking at from such a high altitude. They're looking to cut, hundreds of millions and billions from major departments rather than tweaking what appears to be a small budget for a small agency. On the other hand, this agency has a budget in the $280, $290 million, which seems like chump change probably to congressional members, but at the same time, the waste is incredible because in my day, we decided over 4,000 cases a year, and now it's down to, around 1,000, and yet the overall number of employees and the budget and so forth, even in real dollars, has increased substantially. So I think there's so many big issues pending, but at the same time, you've got Mr. Griffin, who was a general counsel at an international union, and Ms. Block, who had worked on the Hill, I believe on Senator Kennedy's staff, if I'm correct. And, of course, Chairman Pierce is from a law firm in Buffalo, New York, that represents unions, and they were involved in representing a union in a RICO case and so forth. But, the same would be similar if it were just three people from the management side. I ultimately think the answer is to make it less political and get this into a judicial framework where we get away from those issues.
One of the things that, realistically speaking from labor's perspective, is you're looking at, over the last 20 years, a dramatic decline in membership. I mean, the reality is, if you looked at the January Bureau of Labor Statistics findings on union membership, what you saw was just a massive drop in union membership. And some of it had to do with Indiana going right to work, but obviously that's not the reason why. Michigan went down 40,000. Illinois went even more as far as their drops in membership ranks. Despite the fact that you had the president's appointees at the NLRB and some stark changes in the law, what you continue to see are places like Michigan do the only thing they can to try to alleviate labor's effect on their state, which is go to right to work. What you see the current board doing is attempting to do what they can to hold their ground, and I think that labor leaders understand that the political nature of them helps that. For instance, when you take a look at the dues, I mean, historically, when you look at economic fights between the two parties and management and the union, one of the things when the contract expires is obviously the union can go out on strike. They can picket, they can influence, they can use some sort of leverage to try to get their bargaining demands. And from the employer side, they've historically been allowed to go ahead and cut off dues. Well, what the NLRB has done is, in the current session, they've tried to attack that right to a certain extent and say, you know what, we're going to turn back the clock and we're going to say, no, you know what, when that happens, you have to bargain over the ability to terminate the dues. Obviously,
well, that was Kent Hospital, and the National Right to Work Foundation was involved in representing the employee in that matter. The thing that is particularly shocking is it overturned a case precedent of decades, finding that now dues continue even once a collective bargaining agreement terminates until you bargain to impasse or have a new agreement, just to keep the money flowing to the union. And then secondarily, and I find quite concerning, is they also opine that a union can charge for that is germane to the interests of the workplace. Well,
whatever that means.
Germane is subject to, with the Obama board, perhaps buying Subway sandwiches on the way to D.C. to stand in front of the Capitol to protest something is germane. For a Republican board, perhaps lobbying would be germane if it dealt with something very narrow and specific to a particular workplace. All of this is up in the air, and I think we need to reflect on the fact that our labor law is based on a very adversarial system that developed in the 19th century in particular, and I think we need to re-examine and consider keeping the role of third-party representation for some, but we should also focus on allowing people to confer and talk and even negotiate terms and conditions with their employer on their own. An employer is not going to give, John a big bonus and not Sally, because everybody will find out and that'll cause a disturbance. But at the same time, why do we necessarily have no choice other than to pay dues to a third-party union to speak for us? We're in a modern age. We should have a variety of mechanisms for employee voice and allow employers to confer with their employees. This isn't to suggest we're going back to the beginnings of the 20th century when we had company-controlled company unions. We're not suggesting that.
Well, you just gave the union's argument, because that's exactly what they're going to suggest. And the fact that they already have done that. The problem, John, and is that and you're right, with the board being so politicized, is that the board was established to protect the rights and the interests of the one party that has the least amount of say in anything that happens, and that's the employee. And it's gotten to the point where we have these discussions and so many things are happening. The rights of the employees to have representation, the fair representation, because there's a lot of employees who don't want to belong to a union or who have issues with the union that they're not getting representation or fair representation in front of the board. Where's their voice at? And it's getting lost in the politics of what has become the board during this administration. So the real losers in all of this is the workers that really don't know, where to turn.
Well, that's right, and I can imagine where they're thinking, well, if we don't keep what we have, then what do we do? Well, in a modern day, things are not like they were 2-3 centuries ago. In a binary world where things are good or bad, right or wrong, up or down. Now it's more complex, and we should address it and know that there are different types of workplaces, different industries, different types of jobs. So why have only one model, either traditional 19th century union or nothing? That just doesn't make sense. And I think, like all human organizations, unions at the local level, some, not all, but some, are very much like high school student council, where the popular guy got to be the local president, and he stayed in power forever, and then he turned it over to his son, who turned it over to his son, etc. And again, human beings, we all have our downside, but we need choices, and we need different options for people. And whether that will come to pass, I don't know, because Congress seems to be at a stalemate over almost every issue at the moment.
Well, Cliff, John and Cliff, it's interesting what you brought up. In fact, coming from labor myself and Cliff coming from labor, we know what it's like. Just like you said, where you're talking about the boys club. Once you get into the locals or the regions, it becomes all politics, and it becomes all who's the best friend or who's more loyal, and it becomes, like you said, like high school students. And we've seen that many a times, to where on the local level where the workers really don't have a voice, and they don't have an option, because it's very hard to take a complaint against a union with people that you're working with on a daily basis, because the pressure can be really tough coming from your co-workers and your co-members.
Right.
So they really don't. Once they get into the local politics, they really don't have a voice.
No, it's been limited. In my experience working with the unions, is that we all know that there's an unbelievable hurdle you have to get to fight against a union not representing you, but that's at the NLRB level. But more than that, if you want to bring a challenge to the establishment within a union, good luck getting that done. Good luck at the institution trying to work against a steward who's been elected, and like you said, I mean, he's the friend of most of the people. It's difficult.
Well, and then the other thing that's so disappointing and quite frankly sad is, and my goodness, I don't say that all unions behave this way, but just recently, if you go to my blog site at NLRB Watch on the National Right to Work Foundation website, there was a case just a week ago that came out, unpublished decision, where a union engaged in just nasty violence, and yet it was the same kind of thing that happened just 10 years earlier in the massive settlement regarding overnight transportation company, where a union used all forms of violence to go about trying to organize people by pressure, threats, coercion. Everyone, all of us, we're all workers, we're all employees, and we're all citizens. And we need to understand that there clearly must be, and surely there will be, alternatives to something of this nature. I just can't imagine anyone wanting to be enslaved, as it were, by some local union or even an international union that doesn't allow each person to share their own ideas and have a voice, and not be just pushed to the ground by, this is the way we've always done it, and we're going to do it the same way.
That's a good point. We recently, I saw, we're in a public setting. What happened was a group of employees were trying to look at things differently, wanted to negotiate a different way, and the negotiations that were stalled down. Ultimately, they got fed up with the current leadership, and they filed a petition. And what they wanted to do is join their own union. They wanted to actually form, their own company union, not one that's affiliated with one of the major unions. Ultimately, that was pushed back with the resources that the other union had, and it was a fairly sizable group. And what ultimately happened is, as soon as the election came out, it was extremely close, 7 or 8 votes. And afterwards, the leadership of that group, who said we want to have a little bit different tact, we want to be in a union, a little bit different tact, they were brought up on charges. The employer was immediately noticed that those people were now no longer members of the union, and they're still embroiled in their internal problems. So if you voice your concern for a different way of collective bargaining, I mean, the history has been that that's not well taken. There's no round table.
Oh, yes.
All ideas are welcome.
As an organizing coordinator and strike director, and going to the issue as far as threats and as far as violence and as far as intimidation, I will tell you that there's nothing that declares war faster than members voicing their opinion. That is not the same as whether it be the local leadership or the international leadership. And the goal is internally. The goal is to squash any type of activity that goes against what the union deems as in its overall best interest, and they will do it hard. They will do it fast, and they'll be brutal about it.
Well, and I agree, and what's so interesting to me is the unions and the current board members pushed so hard for a notice of employee rights, and that's all being litigated now because it was approved at a time when there were these illegal recess appointees. So that's all held up in litigation. But the point being, here they want to have a notice posted by all the employers to talk about all your rights to join a union, and they would maybe hide, one little sentence saying, oh, by the way, the law doesn't require you to join a union, but the focus is on rights to be in a collective situation represented by a union. But at the same time, we've had the Supreme Court decision in Beck and many other cases since that time, back in 1988, where unions have an obligation under the law to inform employees of their rights in a non-right-to-work state, where they can be a dues objector, they can pay reduced dues, or in a right-to-work state where you don't even have to be a member of the union. But unions need to practice what they preach. They're not, well, some unions, I'm sure, comply, but many unions constantly, you find cases where employees were never informed of their rights to object to paying full dues. And again, I come back, I would encourage employers to share with employees that they can go to nrtw.org on the web and learn about their rights and learn about how to avoid this overarching union pressure. And I would encourage employers and employees to check that out.
One of the things that I've seen lately that's interesting, and goes right to that point, in Michigan, where we're going right to work here, and in this month, if you have a contract that isn't renewed, you're having this fast and furious push by a lot of unions to get a new contract, and not just a year or two or three or traditional 3-year deal. We're talking about 10-year deals. And one of the things that some of the unions have come up with is they don't think they can get a deal done, or they're happy with their deal. So they're putting on the table now, they're calling up and saying, listen, why don't we do a 10-year standalone union security clause agreement? How's that sound? What does that, in that way, employees have the right to continue to pay their dues, whether or not they want to decertify us or not in the future. That's up to them, but we want to make sure we have our dues. I mean, you can tell that the interest of the employees and the benefits that they're trying to get at times don't seem to come in line with what the real story is, which is it is a business, it has to have dues, and then you fall in with the political aspect of it, of who's making the rules. But it all starts with the resource issue, and that's why this decision about what is a due that's chargeable for those non-right-to-work states. I mean, you have individuals that are stuck into a collective bargaining agreement who might not want to be part of the union, but they're going to pay. They're going to pay, even if it's...
Well, I mean, their whole tactic is you have no choice. You will be in our union, whereas that's not how the world works. Whether you shop at Walmart, Target, or wherever, it's because you like to go to a particular store because that particular store offers bargains that you like or products that you like. They're doing something to encourage you to come because of your free choice, rather than being herded into something you can never get out from, and you're under pressure the whole time. I mean, if unions would offer services and assistance to employees that were welcomed and helpful, then they wouldn't need to use these tactics of threats and coercion and pressure.
Well, unions always say, and from my many years working with unions, they always say, well, we love democracy, just not too much democracy.
Well, gentlemen, I'm glad we had this talk today. It seems to be that no matter what happens, we're going to be facing some big changes, either in the way that the NLRB works, the way that those appointments are made, or, in that labor sphere. We're talking about more choices, right-to-work shifts, an NLRB that might be toned down from its traditional pro-labor status now, especially that they've got these impending confirmations in front of them. I think it would behoove us all to keep an eye out on it for the next couple of months here. Thank you so much, Cliff and John, for being on. It was great to have you guys, and I hope to talk to you again soon.
All right, thank you.
Thank you.
Thank you.